reform. That is our focus. That is our push. We are trying to change laws. We are educating people. We are inviting people into the fold. We're trying to create a support system and networking system. A lot of the questions that come up with people in cases all over the country are very, very similar issues. So I want you to put those down. I am an attorney. I've been practicing for 25 years. Yeah, I also have a private practice. I'm going to talk about that again in a minute. So I can't answer all the questions, but there's enough people who've been in the group now for many years, because we've had this group now go over 5 years, that can help answer some of those questions. So first of all, before we begin, I do want to, and hello everybody, good to see you guys, and I do want to talk about April in Michigan for a minute. April Bursman committed suicide, and she's another mom. I mean, we've probably had 5 moms. I can't keep track of everything that's going on, but we've had several moms that have committed suicide when they found that they were not going to be able to reunite with their children. I don't know her story. I read the summary of her story, and I am, it's very, and I've seen some of the stories that our parents have posted in Family Forward Project about the state refusing to return children to their homes. I know it happens. I know it's real. I believe it. I've seen it over and over and over. You are not alone. So I want everybody to just take this into your heart and know how important it is to have some type of support through this process. Now, it's very, very difficult. I want you to look at reaching out by twos, right? If you see somebody who is really in a bad place, if you will reach out to them privately, and if another person can, ideally an accountability team, a support team, an encouragement team should be at least 2 people. And it's very, very tough. And I know you're not lawyers, and I know you're not psychologists, but you know what? If you can help them, number one, assess where they are and what's going on. And some of these issues come up, like I can't get my records, I can't get a court date. You know that those questions have come up over and over and over and over. So sit down and make a list of those, and make like a checklist, and help that person who's going through such trauma and such stress go through one thing at a time. And I've done this. I've had, for a couple of my clients, I've reached out to a couple members of Family Forward, and I said, just be a team with that person. It is so hard. I've seen it. I know people go into black holes if they lose and they disappear. Sometimes I never hear from them again, and they're not willing to fight, even though they know it happens to other people, because it's embarrassing, it's emotional, it's hard. I know that. And so we have got to make that as something that we do. So I'm just going to throw that out there. There's 14,000 of you, and many of you have been around for years, and and you've been through it yourself. Some of your kids, I'm so happy to see that some of you are posting that your children are coming home. Thank you for sharing that with us. It does inspire and put hope in some people's hearts. So I want everybody to really give some thought to this and think about reaching out. So, what can you do to reach out? Another thing that I talk about before is understand what your spiritual gifts are. Know that you may have a spiritual gift of empathy. You may have a spiritual gift of organization. You may have a spiritual gift of perseverance. You have some spiritual gift. And when you do use those spiritual gifts for good, when you put those spiritual gifts to work in God's work, then good will come of that. And, I've said many times, I know that my gifts are advocacy and encouragement, and I try to be faithful to that. I'm not 100% faithful. I try to be faithful to that. Of course, as an attorney, I do advocacy work all the time. So examine yourself, be prayerful about it, say, what is my spiritual gift? What is it that God has given me as a human that is is special, not necessarily different, because you're going to find other people that have that gift. There are other people that have the gift of advocacy. There are other people that have the gift of encouragement or discernment. And there's a list of spiritual gifts in the New Testament, but there are so many more than what's listed there, and you just have to look at yourself and go, what is my heart good at? What do I do? So I want you to really work on examining yourself to do that. So, and I made myself some tea here tonight, so you'll have to be patient with me while I sip a little tea. I've had a whole house full of sick people. I've had little kids with pneumonia. I've been sick. Everybody. It's gone around to like everybody in the household except one person. My 9-year-old granddaughter seemed to have been a warrior through this. I told her it's because she blows her nose all the time and doesn't let all that germ and bacteria build up in her system. But everybody else has been sick. So I'm still at the tail end of it. I was really down for about a week. But I'm coming back around, which is another reason why you haven't heard from me. I made a live on the 1st, a short live talking about the new year, but I haven't been back. So, that tea is really hot. The other thing that has just nailed me to the computer over the past 2 weeks has been this, and it's probably going to be backwards to you because I know it's weird the way Facebook does it. This is what's called a Sixth Circuit brief. All right, do you see that? Now, if you see the names on here, right there, right? So if you've been around a while, if you follow Medical Kidnap, you know the story of Keisha and Chris Turner and their little boys. And she had a baby that was premature, and he was in the hospital for several weeks, and then they sent him home. He's still a little bitty baby. And when he was about 2 or 3 months old, she saw his leg swollen. She took him to the hospital. They did an x-ray of him and found 29 rib fractures. Okay, rib fractures at various stages of healing. Now, these are tiny, tiny, tiny fractures. They are healing at all different stages. None of them are broken. There's no bruising. There's no other signs of trauma. And child abuse expert pediatricians want to say that they've crushed that baby. This is a metabolic bone disease issue. So ultimately, so many parents lose on this. Oh gosh, I just saw another case come up. You would think we would be educating them, but another parent just lost on this. Parents are going to prison over it. Oh, shaken baby syndrome. There's all kinds of medical issues out there that are not being uncovered and addressed. And parents are going to jail and children are being rehomed, and it's trauma. So anyway, in this particular case, we were able to get the children home because I put on a lot of medical proof. So I've taken it to the federal court, and I took it to the federal court under the DCS and the child abuse pediatrician withholding from the court exculpatory information. So this is a very, very, very tough situation. And after I wrote this, I started doing my little outline on civil rights. And like I said, I'm going to have to do the video just on that issue because it's so complex. But there's an issue about government workers either withholding exculpatory information or lying or misrepresenting facts in the pleadings that take away the children. Okay? This is a horrible situation. They've been doing it for years. So a lot of you have heard the Ninth Circuit case. It's called Hardwick v. Vreegan, and it is about the right to lie or not having the right to lie by a social worker. So, Kathleen Arthur's talked about that a lot. A lot of people pass that video around there's a video from the actual oral argument in the Ninth Circuit. Now, the Ninth Circuit is in California. It's California. I think Arizona's included in that, and then Oregon and Washington. It's a really, really big district. Very liberal, but this is actually a family rights issue, so I say it's bipartisan. It doesn't really matter whether you're liberal or conservative. So that case came out in January 2017 on the right to lie. Now, a lot of people woohoo, yay, they can't do it anymore. Wrong. And that's exactly what this case is about. So in federal court, you have 11 different districts, and those districts are in different parts of the country I'm in Tennessee. I'm in the 6th Circuit Court, which is Tennessee, Kentucky, Ohio, and Michigan. All right, that's the 6th Circuit Court. A lot of cases come out of Ohio related to child welfare. I have to look first at the status of the law in the 6th Circuit Court. Okay, now, this is where I'm going to start getting deep on this, and I want you to listen carefully, and I want you to understand part of what has to be done in this process is the development of a body of law that protects parents and families. There is so much bad law out there. And one of the reasons that there's bad law is because sometimes there have been parents who have tried to file pro se litigation, and then the state files a motion to dismiss it. The parent struggles along to try to do some type of a brief to find legal arguments that support their claim. They struggle through it because they haven't been to law school. It's very difficult for them to do. And then it gets into the circuit court, and bam, we have like horrible bits and pieces of law. And so right now I have a couple cases pending in 6th Circuit, and Wendy Hancock is one, and Keisha Turner is another one. These are very, very hard cases, very, very stressful on me. Hours and hours and hours and hours and hours and hours of research and typing and proofreading and fact determination and blah, 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 blah. And we haven't even gotten to discovery yet. So my friend Joe Churchwell, who's an attorney in Arkansas, understands the pain. Very difficult, very hard to win, very hard to even get to trial. You're 5 years before you even get to a trial if you make it at all. And the reason is because so much of the law is written to favor the state and the state employees. So in this case, and I'm going to talk about this right to lie, the 9th Circuit is kind of the exception, and the 6th Circuit has really bounced around back and forth and back and forth and back and forth. Now, here's what's really sad. As far as law enforcement goes, as far as police officers go, it is very well established. A police officer, now understand this, listen to this concept. A police officer cannot go get a warrant against you, an affidavit sworn out against you on lies, okay? And they can't withhold information from a magistrate that would negate the probable cause of the warrant, right? So you can't have a police officer, let's say a car gets stolen in your neighborhood and you were out walking around that night, you didn't know the car was stolen, but somebody, an officer or a neighbor or somebody sees you walking around. So somebody calls in a stolen car report, somebody else says, well, I saw John Doe walking down the neighborhood about the same time, and the police officer does some investigation, but then he finds out, no, John Doe was not even home that night, right? The police officer cannot go to the magistrate with a sworn affidavit under oath to tell the truth and say there's a car stolen and, an eyewitness said that John Doe was in the neighborhood of that car about that time of night and he's a suspicious character. They can't do it. All right, that is a Fourth Amendment violation. However, parents face the same thing day after day after day after day after day after day after day in family court where they take their children. And they use false information, they misrepresent the facts, they don't investigate, they just throw trash in there that they've not even looked into, and then they go and they get an ex parte order and they take your children out of your home. They take your children. Now think about that from the perspective of the child. The child is going into custody, okay? The same thing as if you were being arrested. The child is being taken out of his home, is being confined in the home of a stranger or a group home or a psych hospital or wherever it is. So the child is facing that confinement. And I am, and in this particular case, with Keisha's case, I'm really trying to push the rights of a child, even a 2-month-old baby, to have that freedom to not be put in custody by a false affidavit or by misleading information or by information that is being kept out of an affidavit. And that's exactly what happened. The child abuse pediatrician, Dr. Deborah Lowen at Vanderbilt University, she had reason to know there is research out there that would have told her that this child who was premature, who had lost amniotic fluid, who had low vitamin D, was likely to have metabolic bone disease, okay, which causes basically bones to crack and fracture with incidental handling. So that they withheld this information. If they would have put in the affidavit that they took the children with and said that this is a child that has had a history, and then there was other clues. There was clues that 2 weeks before that he had had a lot of rasping and breathing problems, and they had patted him on the back, and they had patted him vigorously on the back. As a matter of fact, they called 911 to come because they were very concerned that he was going to stop breathing. And so all of these things that could have led and could have put a niche on it. And then, not only that, after they took their child, they had ample time to do an additional examination, which they refused to do. She was pregnant with another child, and when she had her other child 8 months later, they took that baby at 4 days old based on the previous allegations. Okay? So that baby who was 4 days old, which is so important to have that bonding with their mother that first year of life, was stripped away from his family. Now, I went back, and what I try to do and what I'm trying to do in these cases is to really go back in time and really dig through this law, because a lot of the laws that establish parental rights, like Santosky v. Kramer, Stanley v. Illinois, those are cases that came out of the 60s, 70s, okay? It's old law, it's 50 years. But since that, over that 50-year period of time, they have been able to create additional law that has niched away and niched away and niched away at family and parental rights and the rights of a child to be taken. So I spent a lot of time on this. Now, a lot of hours now. There are all kinds of rules in writing these briefs. If you're just tuning in, I'm going to show you again. I just got this written. It has to be under 13,000 words, and then there's all kinds of other rules. It has to be a certain typeface. It has to be a certain spacing. You have to, category. You have to put certain headings. You have to, use the Roman numerals that they tell you to use. I mean, it's very, very, very strictly controlled. But the 13,000 words is, and you can ask to extend it, but they really don't like you to. So you really have to determine in your 13,000 words what is the most important thing. Now, in this case, after the case was over, I had looked at what could we do for the parents. Now, here's the problem with civil rights and parents. Civil rights issues for parents is very, very hard because the statute of limitations is so short. Tennessee is one of like 4 states left that the statute of limitations is 1 year. Most other states, it's 3 or 4 years. I don't know. I mean, we obviously have a sleeping bar association if they've allowed this to get by them. But Tennessee still has a 1 year statute of limitation, and it has to be 1 year from the injury. And so if they take your child on a false affidavit or a false statements or misrepresentations, you've got 1 year from the time they did that. Now, we know from these cases that sometimes you can't get them done in a year. And so a lot of people are like, well, I need to wait until the case is over before I file a lawsuit. And sometimes I'm like, you can't. You've got 1 year to get your action filed. Now, sometimes if you do file it and the case is still pending, the state will come in and ask to stay the case pending the litigation. But then everybody in the government digs their heels in and just goes after you full force. I mean, they're going to find you guilty if you do that. So one option is bringing these cases in behalf of the children and bringing the children's rights, because the children's statute of limitations is 1 year after they turn age 18. And in this particular case, these children were babies. And I went ahead and I filed it in 2000. I don't know. It's been over a year ago now because, again, it takes so long to get anywhere with these. But I went ahead and filed it in behalf of the children and the parents, and thank goodness I did. And I knew it was going to be a trouble with the parents because malicious prosecution, which is the only thing that kind of sounds like it might work in that situation, I have to tell you that civil malicious prosecution is not a constitutionally protected right. So the government can sue you all day long civilly, and you on false information, false affidavits, false evidence, and you have no Fourth or 14th Amendment rights. If anybody has anything different to support on that, that'd be great. I'd love to know. But the malicious prosecution has to be criminal. So if you're prosecuted criminally and they either lied, they withheld information, then it can then you can do malicious prosecution after it's dismissed. And sometimes that happens. I've seen cases. A guy contacted me and came in and talked about his case not too long ago, and they had actually charged him with attempted murder, and then like 3 months later they dropped it, and it was just so that they could get control of his kids during that time period. So much is going on. This is so important. It's so critical. So in this case, I'm going to slip my glasses on here. I talked about the one thing I did bring up in here is parens patriae. All right, now some of you have probably heard of this word. It means the court as a parent, right? Well, that's not really the true meaning of that. That's not the historic meaning of that. Parens patriae literally means the parent of the fatherland, and has been used in cases which allow the government to sue on behalf of the interest of citizens. And then there's a whole bunch of cases. I listed one particular case in my brief. Now, the reason that's important is because one of the issues is children in custody. And there's an old case, fairly old case, 1993, it's getting old now, but it says the Supreme Court has long recognized that the interest of a child in freedom from constraint, the infringement upon which is imposed by protective custody, necessarily implicates any constitutional right in family integrity possessed by the child. It is attenuated by the fact that, unlike adults, children are always in the custody of either their parents or the state as parens patriae. And so what I said down here is that parens patriae, to literally accept that the court or state agency could step in the shoes of a parent and provide day-to-day care and affiliation of a child, is a legal fiction. And I went on to say this thinking regarding a child's right to be free from custody. I said the use of parens patriae is paradoxical. The parens patriae control over a child by a state welfare system does not promise a nurturing environment when a child is placed in the care of an institution or a third party. So this is again just one of these old things that creeped into our law, and sometimes by bad law. If bad cases make bad law, and good cases without good legal arguments even make bad law. So in Tennessee, the right to lie, and I'm going to tell you about that because, hang on here, and I'm going to show you this so that you understand. You get a feel for my work on this. We have to do in these briefs what's called the table of authorities, which means all the cases I had to look up and read. There's page 1. They're in alphabetical order. See that? Page 1. Page 2. Page 3. One more. And page 4. Okay, so do you get it? 4 pages of cases that I went through and analyzed in doing this. Now, I want to I'm going to read you another little section of this, and I know it doesn't come out well reading it, and I don't read well because I think faster than I read, and so I'm looking at it and thinking at it, and I don't read it in a really good narrative, but I'm going to read this paragraph to you. The Sixth Circuit states that there is a qualified, substantive due process right to raise one's child, noting that the right to family integrity is limited by an equally compelling government interest in the protection of children, particularly when children need to be protected from their own parents. However, the Fourth Circuit, okay, so that's another circuit, the Fourth Circuit stated that there is no need to determine which interest, that is private interest or public interest was weightier except when examining the procedural due process rights infringed upon in an emergency removal. However, removals continued in error register no gain toward the state's declared goals of family protection. All right, did you hear that right? All right, let me tell you what that means. So one of the things that I have to deal with in this case law is that there is a 14th Amendment substantive due process right for family integrity, and the Constitution applies equally to parents and to children. But it's saying, and the Sixth Circuit has said, that there's a qualified substantive due process right to family integrity because the right of the government to protect a child is equally compelling. That's what they're saying. That's the Sixth Circuit. The Fourth Circuit, and I would tell you that is probably, I'm trying to think of exactly where that is. Somebody might go on the internet and tell me what area of the country that is. Look up Fourth Circuit Court, states in the Fourth Circuit, and post it for us if somebody can do that. I don't know if you can do it and watch at the same time or you have another device. So the Fourth Circuit has gone a step farther. And the Fourth Circuit has said, and looking at lies within pleadings with people, with the state withholding information, they have said that continuing the removal in error, when you're continuing a removal in error, there is no more reason to look at trying to weigh those two rights. The private interest, you don't have to say what's more important, the private interest or the public interest. Because after you've removed a child, even if there's a mistake in removing a child, once you have the ability to get exculpatory information and you're continuing to hold that child outside of a family, that there's no real gain to the state in what their declared goal is, which is child protection. Okay, I'm not sure if you understand that, but that is a very, very, very important concept. Oh, Virginia. Okay, thank you. Odd, because Virginia has some bad law too. All right, then I go on and I talk about the majority of cases in the Sixth Circuit that address government intervention, which is initiated by a social worker and resulting in the removal of the child, are brought and looked at as it relates to the parents, and ruled at based upon the 14th Amendment substantive and procedural due process rights of family integrity. Sixth Circuit, which is a circuit I'm in, has had a history of flip-flop decisions regarding parents' rights against the submission of false and misleading sworn statements by social workers that lead to either one, an immediate ex parte removal order, or two, the filing of a petition which results in a hearing before the judiciary. And there's a substantial difference in the two. Just like I'm talking about with the Fourth Circuit. If a social worker has investigated and puts in an affidavit that takes a child out of a home temporarily, that is one issue. If they continue to hold that child when they have exculpatory information and they know there is no longer a reason to hold that child, my position is they're continuing to violate that child's Fourth Amendment rights. The child has a right. The children have rights, and we don't have children's rights attorneys within the juvenile court system. And so these rights are being stampeded upon day after day after day under this other mantra of best interest of the children. So I went through and I looked at, I do it in a couple different places here, but there are, in my case, the district court said that, oh, I'm sorry, here we go. So, and also what happens is the Sixth Circuit, now it's a whole lot easier with the internet and we're able to look up cases faster, but, sometimes a case will come out and an attorney filing a brief will miss it. They'll just miss it, right? Because they're coming out all the time. There are ways to really dig in and try to keep that from happening, but it just happens. So in 2014, the Sixth Circuit said that a social worker is a complaining witness and cannot submit false affidavits. That's a case called Young v. Vega. Well, it's what's called in my world, in the legal world, it is an unpublished case. All right, so that means it's not to be published, it's not to be cited, it's not recommended for full text publication, and if it's going to be cited, then you have to qualify that it's an unpublished case. And then in 2015, the Sixth Circuit, probably a different panel of judges, because I think there's like 15 judges in the Sixth Circuit and 3 judges sit on a panel. So a different panel of judges in 2015 said the submission of an affidavit triggers a judicial removal proceeding and in fact is an act of legal advocacy by a social worker for which they should be granted absolute immunity. So the Sixth Circuit went from saying that social workers totally cannot claim absolute immunity to claiming that they can have absolute immunity all within a year. Okay, so probably the 2014 case might not have even been published by the time they came out with the 2015 case. Then in 2018, another case came up which said that a social worker's actions as a complaining witness are more analogous to a prosecutor's decision to prosecute than a police officer testifying by affidavit in support of probable cause. That's a terrible ruling. That's absolutely not true. That is a terrible ruling. Terrible. So you're saying that a government worker in a civil proceeding can go file something false against you and take your kid. I mean, that means they could do it to take your car, to take your home, to do whatever. So that is a terrible ruling in 2018. Then also in 2018, the Sixth Circuit came out with another case. It's called the Brent case, Brent v. Wayne County. That's in Ohio. And this one still is not clear. And this Sixth Circuit case says, well, I know we decided in Young v. Vega that they were complaining witnesses, but that was not published. And then we cited in Barber v. Miller that they should have absolute immunity. And then I'm like, yeah, but that was unpublished too. So you can't give that any priority. So in Brent, and I'm just telling you that the Tennessee DCS is trying to use this case to continue to protect themselves. And I don't think it totally does. It's still not a good decision. I still don't like kind of where it leaves us. But it says the Sixth Circuit held that a social worker that submits false statements in an affidavit that triggers a subsequent hearing is a prosecutorial act for which the social worker is granted prosecutorial absolute immunity. However, Brent also states that presenting false statements in a removal order would not invoke absolute immunity. All right, so other jurisdictions and then I go into Hardwick, and I talk about in Hardwick, it's cited as Hardwick v. County of Orange, where it said that they could not lie to obtain an ex parte order. And then I also found a case out of the Fifth Circuit. And the Fifth Circuit, not sure where that may be. Somebody may want to look that up for me. Maybe Florida or something, or in North Carolina. The Fifth Circuit, courts have found that government action involving false and fabricated reports of abuse may be sufficient to establish a constitutional violation. And that was where a teacher engaged in arbitrary and oppressive action. So it wasn't really a social worker, but still a teacher is a government worker. And then I found a case out of the Eighth Circuit. And the Eighth Circuit, called Heartland Academy Community Church v. Waddle, said that government officials that used exaggerated, fabricated child abuse reports as a pretext for removing a children from the plaintiff's care was sufficient for denying qualified immunity on a family integrity claim. So this is why I'm telling you, I fight, and we have to be able to get some type of some of this legal stuff before the courts so that we can help get a body of law. I've said many times, if you've watched me, criminals have more rights than parents. And the reason they do is because there's such a well-established body of law. Miranda rights, Brady rights, right? So, criminals everybody knows what Miranda rights are. You cannot incriminate yourself if you're in a custodial interrogation. They have to Mirandize you. They have to tell you that, everything can be used against you, et cetera, et cetera. And then, but there's nothing like that with a social worker comes to talk to you, right? A social worker comes and knocks on your door. And she says, well, I'm here to help you with your family. And you go, okay, well, we need help, right? Everybody needs help. And then you start talking to them and you say, well, yeah, my husband and I get in an argument one time, and yeah, he did push me. Next thing you know, your kids are taken out of your house for domestic violence. So it is, a criminal has more rights. And then Brady, right? So Brady material. In a criminal case, there's what's called Brady material. And Brady material means that the state has to turn over to you any exculpatory information that they may have, right? Not so in family court. They don't have to turn over exculpatory information. One of the things that I did, and I think helped us win in the Turner case, is that I required Lowen to produce a copy or cites or references to research, to medical research that would support her medical opinion that the child was crushed and that's the reason he had fractured ribs. She gave me 2 or 3 things. A couple of them are really old, but one of them that she gave me was a 2014 consensus statement from the American Academy of Pediatrics. And in that, it even said that there needed to be a very close scrutiny for differential diagnosis of a child who was premature and had low vitamin D and was a low birth weight baby, et cetera, et cetera. And so that was something I was able to get into the court. Yeah, I know. Following the law, that's a whole different thing. And then I found, I'm going to read you this little section. Read you this. This is from another United States Supreme Court case. This one's in 1979. So this is what I'm talking, this is one of the old cases that I'm telling you that really created some good rights, and then those rights started getting stripped away from us. The removal of a child from his home, and particularly at early stages of development, is a magnanimous breach of the fundamental right and security of family integrity. That's my statement. The forced separation of a parent from a child, even for a short time, presents a serious impingement on those rights. Similarly, delay implicates the child's interest in his family integrity and the nurture and companionship of his parents. So even for a short period of time, that's the United States Supreme Court said that a forced separation, even for a short period of time. Now, what I was able to do, because I had put it in Keisha's complaint, because they have to look at the complaint, and I was able to use, when we had the immigration forced separation and we had these psychologists from around the country like speaking up and saying, oh, this is so horrible, right? The family separation is so horrible. Well, we know that happens every day. But I was able to quote a couple of those, and I put them in the complaint, so I stuck them in this brief as well. And this is a Dr. Ruth of Harvard University who said that the traumatic stress caused to children when removed from their parents can retard their emotional development and damage brain cells. The memory center of the brain is adversely affected. And then there is another Dr. Deutsch from William James College, said that the child's amygdala, the fight or flight center, which affects a child's ability to assess danger, is adversely affected by removal from his parents. The architecture of the brain is changed and can have an overall adverse effect on the child's health. In this case, the child alleged that RBT and CT suffered developmental interruption and emotional damage when they were separated from their parents. Okay, so, and this goes on and on and on, and I could read it, and if I read it to you, I really put you to sleep. But I did spend a lot of time really analyzing the law and going back and talking about it. All right, a couple other things, and I know I'm going on and on here. I like to keep this 30 minutes or so, and I think I've gone over my time limit. A couple of things that have been sent to me, and I want to say people sometimes will send me something that comes up. They'll put it in private messenger, or they will put it, some people have my phone number, and they'll send it to me by text, and I want to thank someone sent me this, and honestly, I can't always remember who sends it to me, so if I don't give you proper credit for it, I apologize in advance. But I'll find something, I'll open it, I'll look at it, I'll go, thanks, I'm going to use this, and then I forget who it was. So I'm sorry. If you did it, just say you did it, put it down there. This is the Supreme Court of Texas, and this came out December the 20th of 2019. And, this is now going back to the state level and what has to happen at the state level. Somebody posted up here, how do we get them to follow even the state law? And it's so true. I mean, in Wendy's case right now, we are battling motions in federal court. And here's one of the issues that's come up is, we complained about the juvenile court proceedings and what had happened. And there was a juvenile court order that came down, and then we appealed it immediately. We appealed it and took it to the circuit court. And then the circuit court, once we got to circuit court, DCS dismissed the case. So under Tennessee law, it says that what happens in circuit court supersedes. That is the final order, not what the juvenile court did. It's like it never happened. And now they're trying to, in our federal case, they're trying to go back and get all the juvenile court records, and I'm having to fight with them tooth and nail when they complain about me having juvenile court records and disclosing them, et cetera, et cetera. Oh, we're going to put them under seal. It'll be protected. It doesn't matter, because there was an appeal of that proceeding, and whatever happened in that proceeding is moot. It does not apply. So anyway, we're still on the battlefield with that, and I'll have to take that to the Tennessee Supreme Court. I put it before the federal court, and I will say, and honestly, I hope they get it. The federal court judges do not understand the proceedings in family court and juvenile court very well, because it's such an absurdity. The lack of due process, the way they handle things, the appeal posture. I mean, it's a very, very unique, and it just doesn't even seem to make sense sometimes. And the federal courts sometimes have a hard time doing it, and so you really have to dig back down into the state court and put the actual black letter law, it's called, that's a law that's written down, that the decision can be made on the black letter law. And there are two issues that come up in Wendy's case, and I know she's watching, and so is Jim, her dad. So one of them is what relevance do the findings of the juvenile court have because it was appealed and the circuit court dismissed the case at the circuit court. So there's no findings. The circuit court, what the circuit court did supersedes it. It's the same thing that if you have a circuit court decision and you then appeal it to the Court of Appeals, and the Court of Appeals reverses everything that the lower court did, and they make totally different findings of fact, and they say, well, we don't think there's evidence to support that. Really hard to get them to do that, but it can happen sometimes. The Court of Appeals opinion supersedes everything that happened in the trial court. So you cannot use that as an adjudication or findings of fact. That is a black letter law issue that we put before the federal court, and are asking the federal court to make that ruling because the defendants are trying to use the juvenile court proceedings and findings. They cannot do it. The second one is the jurisdiction of the juvenile court judge. Judges have absolute immunity, right? We've talked about this off and on and over, and these judges, and some are bad, and I know, and I could tell you more stories than you really want to hear, but they have immunity unless there is a clear absence of jurisdiction. And so what that means is you have to show they had absolutely no jurisdiction. So the juvenile court judges, which are often general sessions court judges in these small counties, have a limited jurisdiction. And the federal court cases say, well, even if a judge does something that he could have had jurisdiction of, then he still has, it's not a clear absence of jurisdictions. For instance, in the circuit court, let's say, and this is just a weird example, but sometimes it works. Let's say you're in a car wreck, and you hit somebody, and they sue you, and they take you to civil court to try to get damages. Okay, so you go to court, they find out you'd had a couple drinks before you got in the car. You didn't get arrested, but let's say you had a couple drinks. And so the judge goes through this court, and he finds that you're at fault, and he awards damages, and then he turns around to you and he says, and I'm going to find you guilty of DUI. Can't do it. Okay, he can't do it because it's not a criminal court case. But you can't sue the judge for doing that because he's still sitting on the bench. He's still acting as a judge. So in our case, we're saying that the general sessions juvenile court judges have limited jurisdiction within their county. And unless there's a proper transfer, recusal, assignment, designation, all of those words that are used by the Tennessee Supreme Court, they have not acquired jurisdiction. This is going to be the challenge of the century. This will be the challenge of the century. So, immunity. Thank you, Carla, for asking. So I can't really get into all of that tonight, but there's 2 United States Supreme Court cases that talk about that. Hang on here. And also, my brain focuses like this. Somebody can probably post those faster. There's 2 cases. The first case that came down about judicial immunity from the United States Supreme Court, Fisher v. Bradley, which was in the late 1800s. And in that case, the first case, they said, well, I'm sorry, I'm trying to catch up and watch some of your comments here. But on the Fisher v. Bradley, they said, well, you cannot sue a judge unless he was malicious in what he did, right? Ooh, well, people are still suing judges because some judges are malicious, right? And then another case came out called Stump v. Sparkman. And in Stump v. Sparkman, and I'm going to tell you about this case because it's a horrible case and it's an example of total judicial overreach. But it was a case about a young female who was an adult who had some mental disabilities. Okay, now I can't recall off the top of my head whether they were learning disabilities or whether they were psychological dysfunctioning, but she had a mental disability. She was unable to function on her own. Her parents, she's already an adult, her parents went to court and got a judge to sign ex parte that she could be sterilized, that they had permission to consent to sterilize her. And they took that order and took it to a doctor and had her sterilized. Well, then somebody comes up in her behalf. I don't know who did it. It's amazing that somebody even did it. But they came up and they brought a lawsuit in behalf of her, suing the judge, saying that the judge did not have jurisdiction. And in that case, they said the judge had jurisdiction because he was acting as a judge and he could have done what he did. So it was still within his jurisdiction. So you have to find a clear absence of jurisdiction. And one particular case that I found, I don't have that brief in front of me, but it really said that if it was a court of limited jurisdiction, you were more likely to be able to find that the court did not have jurisdiction because most judges have a general broad jurisdiction. That's a whole nother issue. Okay, so that's that. All right, now, again, we're going into 2020. I don't have specific travel plans set up right now. I need to start taking a look at that. I'm honestly, from mid-December to now, which is the last 30 days, I've been just kind of stressed between the holidays and a brief and sickness. So those 3 things, 3 strikes, you're out. That was enough to keep me down. Actually, I was able to get away today and took a nice long nap and then nice hot shower, and that's the reason I could come on and join you. So it's been very, 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 very stressful. I know this whole process is very stressful. We're fighting a huge, huge war. We are fighting the war. I mean, it's the war of the devil. And I always think of something else I want to say. In part of this process, I've been looking at the history. I'm always following the history. How did we get where we are? Why are people not talking about it more? So, and of course, I'm always watching YouTube videos, educating myself on history, primarily from things that have occurred since World War II. So, everybody knows that and I hold myself back from try to hold myself back from being labeled a conspiracy theorist because this is so global and there's so much going on with the taking of our children, the missing children, the pedophilia, the child trafficking, the child sacrifices. It's so huge. Some people don't go that far. Don't say that. Oversight committee. Actually, I'm going to touch on that before I go on because, getting parents involved is one thing I have tried at every level, okay? We have, through the federal government, they're supposed to have citizens review panels. Guess what? They never invite parents. At the state level, they're supposed to have an oversight committee. Guess what? They never invite parents. They have a second look commission. They never invite parents. They have a Tennessee Commission on Children and Youth. They never invite parents. I went before the legislative committee last year and I said, I want to bring parents. They wouldn't let me bring parents. They do not want to hear from you. So our voices, yes, Our voices are very, very critical. Okay, so I'm going to take you back now. We're going to time warp back to the 1970s, okay? So, because you need to just kind of put this in your head, we have often talked about through Family Forward Project that the start of this, a huge part of the start of this was the Mondale Act in 1974. Senator Walter Mondale, a Democrat, who later became the vice president of Jimmy Carter. Okay, 1979 became the vice president for Jimmy Carter. Walter Mondale got CAPTA passed, CAPTA, Child Abuse Prevention and Treatment Act. If you study that act, it was about poverty. It was about poverty. They didn't want to put the word poverty in the act, and so they used the Child Abuse Prevention and Treatment. It sounded better. What it was the first huge step in which the federal government started tossing money out to the states for their child abuse programs and foster care. Huge amounts of money. And then it's within the next 20 years that we have the ASFA, which is the Adoption and Safe Families Act. ASFA passed by the Clintons, okay? Bill Clinton was in office. Hillary Clinton brags about it. If you watch the 2016 Democrat Convention, where Bill Clinton is congratulating Hillary Clinton for becoming the nominee, he specifically talks about it, and he gives her the credit. He says she is the one who got that pact. So we have 1974, 1997. One of the things that I am looking at is this whole, from a global perspective, and what we need to do. We need to wake up, and you all need to have voices that are heard, is the UN, the Agenda 21, the Trilateral Commission, okay, which was to destroy families and weaken our society, okay? Mondale is in the Trilateral Commission. Jimmy Carter's in the Trilateral Commission. Bill Clinton is in the Trilateral Commission. Now, I can't find the thing to support it, but I would assume that Hillary is as well. At least Bill is for sure. So we have, and you can go and there's some good videos. I actually posted one. It's about an hour long. It's kind of long and tedious, but I did post it on just my regular timeline. If anybody wants to really get into what is the Trilateral Commission and what does it do. Oh, and also, all you Fathers' Right people, Richard Gardner is part of the Trilateral Commission. Richard Gardner is the one who promoted the parental alienation syndrome, and he did it with no evidence. It was a scheme to cause conflict. Okay, it is a scheme. It is a trip against against families, against fathers, against mothers. He published his own books because he couldn't get anybody to publish it. He did not have research. He used one or two case studies, and he just made up the theories as he went along. Richard Gardner is part of the Trilateral Commission and wrote his book in about late 80s sometime. There's a couple other people I'm looking at from things that they did after World War II. One of them is Heimke, who is German, right? And he wrote the book on the battered child syndrome, which is the first book that really just started talking about, looking at the whole entire child. Now, I'm not saying that's bad. I'm not saying it's bad, but I'm saying that the paradigm shift to parents are no good, and the theme that's circulating in the heads of our government officials is parents don't do it well enough in education and sex education and vaccines and healthcare, in food choices and in parenting in general. So this is a major paradigm that has to be transformed, and your voices matter. So, I've said this before. I'm not going to get into it now because I'm going to cut off here in about a minute, but you need to know who your state rep is, who the people are that are representing your interest in your state, federal, and local governments, okay? And your voice needs to be heard. Okay, all right, we have... I've gone over my 20 minutes. I try to keep it 20, 30 minutes. I've gone over that. Y'all have been wonderful. Thank you so much. Be vocal. and help other parents in this movement. Help them. Get your team. If you see somebody who's, feeling really, really bad, get a support team. Talk to them. Help them with their assessment. Find out what your spiritual gifts are. Help them learn to document. Help them keep focused. Help them get a checklist down of what they need to do, what they need to ask for when they go to court, what they need to ask for from their attorney, how to write down their witnesses, how to ask for records, etc. Okay, a lot of you know a little bit about that, and it'll help me a lot. I am a private attorney. I'm in private practice. I work all day long. I can't talk to everybody. Okay, I love y'all. Please be good. Please pass this around, and let's educate, and let's share, and let's change this system. I appreciate you. I love you. Keep up. Keep it up. Just keep it up. Thank you so much. Bye-bye.